be sophisticated. No laughter. Franchisees, as I said, franchisees have perceived to have been abused for many, many years. What will happen is take a fast food type of franchise arrangement. The model has often been that they get to hang a sign outside, but any of the food that's sold in there, notwithstanding the fact that they could go and buy it from a high quality store down the road, let's say Woolworths or something like that, they can't do that. They must in fact buy it from a central kitchen owned by the franchisor. The franchisor gets to make a bit of extra time on the side, okay, in addition to his franchise fees and all royalties. That's now been watered down, and the franchisee now has extensive rights. It's not fit for today's purposes that I'll go into that, but if you're a franchisee or a franchisor, you need to be mindful of the landscape change. Then one needs to be mindful of what a transaction is. So it's an agreement for the supply or potential supply of any goods or services in exchange for consideration or the actual supply of that good or service. Again, not for today's discussion, but what is very, very important is for you to decide whether you're supplying a good or whether you're supplying a service, because different liability flows from that. A lot of people will want to rather be supplying a service because they don't fall under the strict defective goods sections. What might shock a lot of people is, as I said to you, that there are certain transitional provisions which are already in force. The provision under Section 61 of the Act dealing with defective goods is currently in force. And I'll be surprised to see how many people in this room, let alone outside, have taken adequate protection for that. You can't sue for it yet, but come the 24th of October, anybody who's bought any of your products has the right of action on the 25th of October. It's already there. Who's warned you about it? Just think about that. Are you in the supply chain? Okay. If you supply an exempt organization, does that take you out of the running? No, it doesn't. Because if you have a look, the consumer can look to anybody in the supply chain. Producer, manufacturer, importer, wholesaler, marketer, retailer, etc. So think about this scenario. You're the Hyperama, you get your goods from Samsung in Korea. That relationship, I think I can positively say that they'll both be above the thresholds. So the relationship won't apply between the two of them. But PJ goes into the Hyperama and buys a Samsung TV set. I am a consumer, so I have a right against the Hyperama, against the person who brought the Samsung TV into South Africa, the wholesaler, the importer, the people who marketed the product to me, and Samsung. So even though your relationship, your supply between A and B might be exempt, if it's ultimately supplied to a consumer, that consumer has a right of action right the way up the value chain. So what does that mean? That means that you need to have proper back-to-back agreements and indemnity relationships between your suppliers. So, for example, if I was trading with a supplier out of China, would I want to litigate in Beijing? Unlikely. Too expensive, don't know how to speak Chinese. Okay? Don't understand their legal system. So what would I want them to do? I'd want them to put up a bond of security in South Africa. It guarantees that there's money here, that in the event of a claim that I'm called upon to pay, that there's money here to satisfy that. And I know what you're going to say. They'll never do that. Then don't deal with them. That's the relationship that we have in South Africa now with our law. And if you want to bet that you're never ever going to have a test in terms of this act, then you're a gambling man or lady. But I wouldn't suggest it. Letter of credit, bond of security, some kind of redress that you can actually operate against should you be called upon to pay. I still obviously believe that the common law benefits of being able to join any other person to an action will still exist. So, for example, if I'm sued because I provided goods which I've received from a third party, I will be sued, I bring an application to court to join that third person to bring him into the action. All fair and well, but much easier to have the bond of security, isn't it? And how do I join somebody in a foreign country? Perhaps can be done, difficult, costly. So I need to think proactively about what happens if I'm tested in terms of this act. The Samsung case, it's no aspersion on Samsung, it's simply I use them as an example. What I say here is how far this act reaches. Let's say I go and buy a fridge and it explodes in my kitchen, and my domestic is injured by that. She would be considered a consumer because she has been affected by this defective good. So think how far these breadwinner claims can go to, and potential lawsuits can go to. And I can only say again, education and insurance. Educate your customer on what he's buying, and not hidden in some kind of small print somewhere. Set out in terms. This is what you're buying. This is where it's dangerous. You know, we've all seen those American cups of coffee, hot. Well, what were you expecting? But that's where it's going, okay? That's where it's going. You're going to need to be speaking to, unfortunately we were talking outside earlier, dumb it down. Dumb it down. Take it to the level of the most unsophisticated person you ever think you'll be dealing with. And this comes again, this talks to the education of your salespeople, the education of the people that you employ. How will they gauge a consumer? How will they gauge a sophistication? Are your contracts, your supply agreements, are they going to fall foul of this? Is anybody going to be able to read them? Do they contain all those Latin bits that nobody, including the lawyers, understand? Can't have those things anymore. So I say, can you protect yourself? Yes, obviously, insurance. But more importantly, you need to go home today and go and have a look at all of the systems that you have in place, whether they just be normal sort of IT type of systems on how you provide products to your consumers, or whether it be the agreements that you've got in place, your distribution agreements, your agency agreements. Think of the traditional agency agreement. You supply XYZ product on behalf of XYZ company overseas, and in there is an indemnity. He closes the loop. So now, if you're the hapless person chosen by the class action lawsuit which cherry picks you, they can go after them if they want to. But if they're satisfied to deal with you because you're in Cape Town and they don't have to go and chase somebody in Johannesburg or Swakopmund or wherever else in the world they might find themselves, that's the end for you. Can you put indemnity clauses in your agreements? Can you say, no, well, you know what, I've got a big sign there, I own a motor car dealership, and you bring your car here for a service, and can't you see on the wall there it's parked at the owner's risk? How many languages are you going to put that in? Do you have the wall space? Do those even pass muster anymore in terms of this act? They're full to be decided whether those so-called exclusionary clauses pass muster. And there's been a plethora of legislation, well, not legislation should I say, but case law on how these so-called disclaimers are to be considered. They're certainly to be considered in the most strictest light against the supplier. The consumer is always going to get the benefit of the doubt, even if you could get through the hurdle that your exclusionary clause wasn't dismissed on the basis of being an unconscionable contract term at all. So I know now I'm talking to myself and the other professors.